Dictation start in 5 seconds. Start. The question involved in the appeal is as to the right of the appellant to verify the disability certificates issued by the medical board under the provisions of the Persons with Disabilities Equal Opportunities Protection of Rights and Full Participation Rules 1996. The respondents applied for BTC training course under the physically handicapped category on the basis of certificates issued under the aforesaid rules. It was claimed that they completed the training and had been offered appointment in the primary schools run and managed by the state government. A complaint was received from Bharatiya Biklang Sangh of illegal usurpation of the quota reserved for handicapped persons on the basis of fraudulently procured certificate without suffering from the disability certified under the rules of 1996. The state government issued an order dated 3/11/2009 making a provision for constitution of fresh medical board in order to verify and assess the disability of the candidates. The candidates questioned communication dated 15/7/2010 issued by the Director, State Council for Educational Research and Training based upon the GO dated 3/11/2009 requiring them to appear before the medical board constituted in order to assess the disability. Out of the 234 candidates selected under the handicapped category on being examined by the medical board, it was found that 21% of the candidates were not handicapped. A single bench of the High Court of Allahabad by judgment and order dated 31st August 2010 dismissed the writ application, holding that under the rule framed in exercise of the powers under subsections 1 and 2 of section 73 of Persons with Disabilities Equal Opportunities Protection of Rights and Full Participation Act 1995, the general eligibility to apply for facilities, concessions and benefits admissible under the scheme of the Act is subject to such conditions as the state government may impose, and the state government has imposed conditions in the order dated 3 November 2009 of Constitution of the Medical Board for verification of the disability. Even otherwise, under the rules, there can be a review of the decision upon representation by the applicant and fresh order can be passed. Thus, the certificate issued is not final. On appeal being preferred, a division bench of the High Court of Allahabad by the impugned order has allowed the appeal and has held that while the certificate has been issued in accordance with the rules of 1996, roving inquiry cannot be made until and unless fraud has been detected. It is not permissible to reopen medical certification carried out under the rules of 1996. However, the High Court has directed that a physical verification may be made, and if the candidate has not been issued certificate of disability or otherwise, or that he does not suffer from any disability, so certificate which entitles him to such a certificate in the event the candidate can be subjected to fresh medical test. Accordingly, the directions by the government in the order dated 3 November 2009 and by the director on 15/7/2010 for physical verification be construed in the aforesaid manner. Done.